All right, folks, welcome to the Franklin Hampshire Field Training Hub and Western Mass Public Health Association's workshop on writing an order to correct. I'm Phoebe Walker. I'm the Director of Community Health at the Franklin Regional Council of Governments, which is the host of the Franklin Hampshire Field Training Hub. With me and somehow as your name for many of you is my colleague Liz Jacobson Carroll. And here but not presenting is our favorite field trainer, Bree Dupress, who's out on maternity leave. So all is well with Bree and the baby. Thank you for those who've asked, but we miss her. So we are so excited to have Paul Halfmann here. And as you may know, Paul is now a public health consultant, but was for many years the associate director of the DPH Division of Community Sanitation, has been an instructor at Worcester State University, and a trusted expert to all of us in all things housing code. We're really glad you were here today. There was such a huge response that we had to change it to a webinar. And as you are noting in the Q&A, for some reason, many of you are named the same thing as one of our colleagues, and you can't change your name. We're sorry about that. Put in the Q&A who you are, so we'll make sure you get your CEUs. Don't worry. And we are recording everything here. Questions that don't get answered, we will keep track of in the Q&A and send out an email after. But Paul has graciously said that he would be happy to take the questions as he presents. So if you've got questions about what the materials are, you can just have him answer them in the moment by putting them in the Q&A, and then I will get him and ask him. Okay, let's take it away.
All right, thank you. Let me do the famous have to share my screen and looking into nowhere for a minute.
4 years into Zoom, we're still all loving it.
We all know that one.
Excellent.
Okay. Well, welcome everyone. I was rather surprised to hear about the number of people that had registered, and I was talking to Catherine Daigle about this last week when I heard the numbers. And when I said I was surprised, she said she wasn't. Catherine, you may know, was from Bedford Health Department. She's now with Community Sanitation. She's a senior housing trainer for the Hub trainers. And she said she wasn't surprised because it's never been addressed. Nobody is ever done how to write an order training. And I know Regina had done it in the FIT class. I'm doing it a little bit different than what she had done, trying to put a little bit more of a rationale and show you a couple of forms that I've tried to work with to make it easier. So, and as she said, any questions, just hit me with them as you go along. So last year, I know you all had a lot of fun digging back to 2018, trying to pull out all your files and order to correct and inspection reports and folder after folder after folder. And it wasn't any fun for me either, even though I signed up for it, because I was the one that did all of the reviews for all the housing issues. And it turned out to be over 2,000 documents to look at. And I just wanted to put up here a little bit of what I found. And if I point any out, I just want to give you a disclaimer. I have no idea who did this anymore because it was a year ago. And when I looked at them all, I don't know who did what when I'm talking about it. So I'm not singling anybody out. But some of the things I ran into, and you have to understand, when we were given the documentation, we had to take it at face value. We weren't allowed to make assumptions like, oh, I bet they meant to do this, or they probably forgot to include this. If the instructions said that you had to include the order, the inspection report, and reinspection, if it didn't have all three, it did not meet. Those were the criteria we had: meets and does not meet. So that was where I was limited in what I wanted to, how I wanted to score it, even though I had some ideas as to what was going on, but I couldn't do anything about that. So one of the things that came up right away through, I don't know how many of these I ran into, were unsigned orders. And I have a pretty good idea what happened. And I found out not too long ago when I was talking to one of the health agents and we were talking about it. She said, oh, I know I got dinged on these because I keep the Word version of the order on my desktop. And when you asked for it, that's what we sent. And the signed copy is already gone. So I said, well, I think one thing you may want to think about is, and what I had everybody do a community sanitation just because we had our documents subpoenaed quite a bit, is I would have them sign the Word document and then scan it and save it as a PDF. So if you ever had to distribute the documents, you had the original signature on it rather than just signing another document and sending it out. Would anybody pick up on it? I doubt it. But what I want to emphasize today is that I know a lot of the courts, everybody has the housing courts now, are getting a little sharper on how they view documents. And I had last summer 3 boards of health call me and ask for help because they had cases thrown out of court because they didn't identify the conditions deemed to endanger. So at that point, people started asking about the order to correct. And I thought the best thing to do when people were asking for a presentation on this is to do it by the letter of the law. And the reason for that is sometimes it seems a little crazy, a little picky. Paul, they're really going to look at this? I don't know. But if you've ever been to court, I used to be in court all the time, especially with lead, with big dollar items, and everybody was looking for an out. Lawyers would pick these things apart if they had to. And if you had a very important case, something you've been working on for years or at least a couple of years, it was hard to get in, it was hard to get something done, it was hard to check, it was hard, the whole thing is just a battle all the way. So you get to the boiling point, you go to court, and just to have it thrown out because of a technicality, it's very difficult to try and start over. So my thought was, we're going to go through this as the code explains it. And then I have also a little interpretation I got out of DPH as we go along. So my advice is on the order to correct, when you sign it, scan the copy and keep that on your hard drive. If you get your documents subpoenaed, you want to have that original signed one anyhow. There were times, I don't know if DPH still does this, but we went through a period where they wanted everything signed in blue. So if copies or scans were made and it came out in black, you knew you weren't dealing with the original. I don't know if any of that stuff matters. I doubt it, because it's if you have a scanned copy, it's just that, it's a copy. So I don't worry too much about that. Emailed orders. There weren't that many of them, but they were all across the gamut where people would attach the order to an email and send it out, and they would make no other notation. And I've talked to a lot of trainings that I've done. People have said, well, if we send it by email, we can do a return receipt. So as soon as it's open, we get the receipt. And I remember a couple of courts saying, years ago, going through the FIT class over and over again, the court said, no, that doesn't fly. You don't know who opened it, on and on and on. So I look at it from the standpoint, if you were in the FIT class, Chief Sullivan and now Chief Horan had spoken, and they were very firm on these things. So right off the bat, email anything like that that's supposed to be in order just isn't going to fly, no matter what. I will always.
Sorry,
yes.
There was a question about inserting the electronic signature into a Word document.
That's fine now too, but that's fine. But what I would also do is when you insert, like mine, I do that all the time. Now I do mine in blue ink. So then if I do a PDF just to save it, sometimes it'll be, well, it won't show up black and white. It's still blue. So it's still blue, but yes, electronic signatures have been approved. So you're just saving the Word document at that point. So it's not necessarily going to be PDF. So that's a good question. So that does work. We used to use at DPH the electronic signature all the time, and that's fine. That'll probably change a lot of these documents in the future because there is another capacity assessment coming. I don't know when. I think it's only going to be for 1 year rather than 3. So get ready for that one. But yeah,
Thanks.
Inserting electronic signature is fine.
Great. And for folks, I'm seeing the occasional hand go up. Given that there are 150 of you, please just put your question in the Q&A. I've got it open. I will make sure that Paul gets your question.
Yeah, I don't see any of the hands. So hands, fingers, right. I don't see any.
Hands aren't,
anything.
Put it in the Q&A.
So,
thank you. Okay, off you go again.
So on the email, it went across the board in emails they would send an order to correct, and sometimes the order still wasn't right, but it was sent that way, and that doesn't fly. There are other times where I would see emails that started out kind of like an order, but in the body of the email, they would just not even cite violations. They would just say, there's a broken window here and a broken window there. And at the end, it would be something like, um, please go after this right away and let me know when you're done. And that's kind of way off base when it comes to what you can do. I've had some people, I don't know who they were. The email would just be in like a conversation. I noticed that when I was there the other day, there was a couple problems here. Could you run over there and take a look at it and take care of it? No mention of an order or follow-up or anything. So emails in general will not suffice for service. So there's no point putting an order in there and sending it along. I remember years ago, I don't know if anybody still feels this way, but I remember years ago, I had somebody ask me about emails and orders, and they had told me that they don't send out orders because they don't want to embarrass the owner. And I said, well, embarrass or not, that's what is required. And my feeling was, well, how do you enforce that? And they said, well, they always let us know when they get the work done. And I said, has all the work always been done? And said, no, but we have a pretty good record. And a pretty good record really doesn't mean much when you got people calling you all the time complaining about the fact that nothing's getting done. So the structure of the order is going to be critical, and I have one for you to take a look at too as we get through. Yes, you're muted.
There's a related question about whether you can send the email because it's the most expedient way, but always follow up with a certified receipt. Do you see any problem with that?
As long as you're using one of the approved certified means of service, you can email anytime. Send them an email and say, there's an order coming, pick it up. Whatever you want to do, but you still have to go through, and there's a slide on proper service. So anything in addition to what is required is fine, but you just can't use that as the sole means for service, for serving an order.
Thank you.
One of the biggest ones I ran into, I think, is the missing citation references. There would be very good descriptions, but there would be absolutely no citation references whatsoever. So if anybody wanted to look that up, they couldn't. It also runs into things with conditions deemed to endanger, which is the next one down. These two kind of go hand in hand in some cases, but the code's very specific about having the appropriate citation reference so that you have a means to identify where this found in the code, but exactly what the code requires. Because if they can't look that up and there's no reference for what the regulations require, they're kind of left in the lurch, not knowing what it is they're supposed to do unless they call you. And if you have a relationship where you can talk to them, that's fine. That doesn't always seem to be the case, and that doesn't always work. So the citation references are critical, and it's a little more difficult by now because the code is new, and everybody had from 1969 on with the same old numbers, and now we changed the numbers, and that was done intentionally so that everybody would read the code and learn the numbers. And it's been almost a year, and I think I know half of them now, and I helped write it. And so I know it's difficult, but it's something that you really need to put in there to make it a legal order so that you don't run into an issue with all that work and have one of the clerks or the judges say, well, what's the reference here? The conditions deemed to endanger were the big three that with the cases that I ran into with local health. And I also ran into one many, many years ago. I think some of you may remember that there was a family that lived in a van down in Sturbridge and Southbridge, and they used to bounce around back and forth, and both towns took a couple of years trying to get everything done. And at one point, I went with them and they did a housing inspection on a van, and you can imagine how many violations there are when you look at something like that. And we ended up in Superior Court, and I think it's because the occupants took the town to court, and it ended up in Superior Court. And the case right in front of us was a tax case for one of these very large property owners, and the judge came down and just slammed him. So I figured, well, okay, good, he's strict, we'll be in pretty good shape. And when it started, we had to describe what was going on. I was in the background, I didn't do it. And then I saw that the judge, he's looking at the order and everything, and they're explaining everything. And he said, geez, it sounds kind of strange. Are there any of these that are more serious to do than others? And they said, yeah, there are. And I didn't think anything of it. And all of a sudden he said, what would you consider some like a condition deemed to endanger their health and safety? And I said, oh, I don't think I like the sound of this. And they go, oh, yes, Your Honor, there's plenty of them. They just took the orders, but would you show me where they are? And 2.5 years on that case, thrown out the door. So it does matter. And I know they're looking at these things now. I've had people around the state with different courts, and there's different, there's more than one judge at each court now. So now you not only have different opinions of courts, you got different judges in the same court. So they're paying a lot of attention to these things, and they're following the letter of the law. I know that. In a lot of cases, they want an attorney there. So they're holding that to even a higher standard. I know years ago when I used to be in the housing court, they were a little more forgiving because we were allowed to represent the state or the town, whatever it was. So they were a little more forgiving on maybe we didn't have the right procedure or we kind of fell short a little bit. But if our inspection was solid and our attempt to get the work was done was solid, they'd let it ride. Well, I don't think that's happening in a lot of cases anymore. If it isn't your court, good, but you want to be ready and do it the right way. Yes. You're muted. You're going to learn.
It'll take me a second. You have a question from the audience asking about when you have here that one of the things you found missing in the capacity assessment housing orders were missing citation references. And one of the attendees is just asking, are you suggesting that the citation references need to be in the inspection report as well, or just in the order to correct?
We're going to get to that.
Okay.
I got a couple good slides on it, so I don't want to spoil it yet. You got I don't want to take you all the way to the end just yet. We are definitely good. You won't even have to remind me because that's part of it. Incorrect timeframes all over the map. I mean, there were people that there were I should say orders. There were orders where there were a ton of things that were wrong. Conditions deemed to endanger all over the place. It is giving them 30 days, given 21 days. It was really kind of all over. I had some say, let me know when you're done and I'll come by. I had one that was all conditions deemed to endanger, and it was an order to contact the Board of Health to discuss a plan to do the repairs. So that was kind of a little bit out of line. So there were a lot of those missing. And the code now, I mean, well, it was pretty, well, not really clear, but I think it's a lot more clear now. Basically, when you have conditions deemed to endanger, we'll go through this about 1 day. And then when you have anything else up to 30 and you get to pick. So you have to nail that down as well, because if you leave it up in the end, call me when you're done doesn't give you any kind of time frame or reference as to when you have to do any enforcement. So I think if you went to court, some would probably sympathize with you, but I could also see a clerk or a judge saying, well, what was the time frame they were supposed to have? And said, well, I just told them to call me when they're done. And they said, well, how long are you going to wait? And you don't have an answer for that. So it's just another part of the order and it's glaring right up front. So it's not anything that's hidden that people may miss if they're reviewing it. Some of the more technical issues, even though they're very important, was the time missing a statement regarding a right to a hearing. That's a big one. And one of the things I ran into was with the emergency condemnation orders. I hit a lot of people in the beginning because there was no mention of a right to a hearing. And I said, boy, this is getting to be quite a problem. And I noticed that it looked like the condemnation order was the one that we had on our website. So I went on the website and I noticed that one didn't have the right to a hearing either. So the whole order was shot right from the start. So I know that's been fixed, and it took a while to get it done. I think it's up. I better not say it. I think it's done, but it was in the works a long time ago. Whether it's done or not, I don't know, but it's listed in there what has to be done. And we're going to get to that because I have copies of orders, different things that I want to show you that are going to explain some of this a little bit more. So I talked about calling the Board of Health for a schedule within 3 days or when the work is done. Re-inspections are required. It's also required to let them know that you're going to have a re-inspection. Now, a lot of people say, well, how can I tell them on what date I'm going to be there for the re-inspection when I don't know what day they got it? And you can't, you don't know. So, I mean, you just do it from, and I saw a lot of advice in there that, or clarity in there that I saw from many towns that I thought was really good. And they would clearly state that re-inspections and the deadlines for repair they start on the date of you were served, the date you got the order. And a lot of people, I don't think it really understand it. I know a lot of occupants don't understand it. When you send a copy, they think the clock starts the minute you walk out the door. So I have to give a lot of people props on that because they did a very good job on being clear about that. However, on the other side, when it came to documenting re-inspections, I couldn't really tell in some cases if there were re-inspections because I'd see some things scribbled out like this. I didn't know if they didn't mean it or if it was done. You'd see a check mark somewhere, and I assumed, shouldn't have, but I assumed that it was a re-inspection, but there was no date. And there were some that just had no mention of a re-inspection whatsoever. So I have no idea what was done there when or if they were even done. Click on it. So your orders starts with the inspection. And I use this one. This is the same slide I use for preparing for court too, because you really are protecting yourself when you follow what's required. So you all know that in the conduct of inspections, and I shouldn't say you all know because I know a lot of people don't know because we've talked about this in the past. But at a bare minimum, when you go to do an inspection, first of all, you have to offer a comprehensive inspection. It doesn't mean you have to automatically do it. If they say, no, I just want you to look at my broken window, that's fine. There are some communities, and there's nothing wrong with this either, that just do comprehensive no matter what, because they've grown tired of an occupant calling them with the violation of the week and going back to the same house time and time and time again. And I know this is happening because people call me up and they say, how many times do I have to go back before I can tell them I'm not going back anymore? And I said, I don't know. I don't think there's a date. And I always say, call Cheryl Sabara, because not being an attorney, I don't want to say anything like that, but I get it. I know how it can be a problem. So sometimes just doing a comprehensive is fine. But if you're just going to look at the broken window, not a lot of people, including me, I get very tired of reading quickly, so I don't always read the last sentence of a paragraph. Sometimes I don't even read the paragraph. But what it will always say is each inspection consists of, at least at a bare minimum, looking at the alleged violations, the complaint, and the standards found in 630A. That's the old 751. So in other words, when you're doing an inspection and they say, no, I don't want comprehensive inspection, I don't want just look at my broken window and be done with it. You also have to look at the conditions deemed to endanger. Now, people have asked, well, how do I have, you mean I got to do a comprehensive inspection? And remember, I'm no longer a DPH, I'm not a lawyer, but it's always been my opinion, you know, if you take a walk through that you can see there's nothing glaring sticking out, you're probably okay. And probably okay is the best that I can do, because that's just, I don't have the authority to say this is exactly what you have to do. But keep that in mind, that you have to be able to look at those at least do a quick glance to see if there's anything really glaring sticking out that you may have to act upon immediately. You have to record, and these are the requirements of the code. So this is where it's telling you what you have to put in there. It's not me this time. You have to record the violations noted and identify the section. So when I say you have to have the proper citation number, it's the regulations that are saying that. And you have to inspect the areas based on the type of complaint, these, which are really kind of the same here. When you get the pest and moisture, you're looking at the outsides and things. But if you got a moisture issue, you want to pay more attention to things where moisture may be in the basements and that sort of thing, so that your inspection is covering what it is you're trying to do. And once again, identify conditions deemed to endanger. You're going to see that come up all the time. Now, what about the form? And I want you to pay one attention to one thing, and you'll catch on here in a minute. It says the form itself. And so when we get to the order, I want to talk about that. So it tells you, I have to move this thing out of the way. I can't see. Okay. You have to have the name of the inspector, the date, time of the inspection or investigation. You remember investigation, say a neighbor complains. Your investigation is to look in to see if there's grounds for an inspection. The location of the residence. I can't tell you how many times people would send me an emergency condemnation order and say, can you look at this before I issue it? And I would look at it and say, well, you may want to put the property address on it before you send it out. So you just have to be really careful on that. The need for an additional inspection by a specialized inspector. What does that mean? If it's a structural issue, if it's an electrical, plumbing, you don't have the expertise to do that, you don't have to guess. And at that point, if that's the only part of the inspection that's left, you can delay finishing your inspection based on that, and then try and get an inspector to at least give you some advice. I know in a lot of cases they're not going to go with you, so you can try and use the information that you can get out of them. A description of the conditions constituting violations. In other words, where I'm citing 500 and say, well, there's a hole in the wall, and that's the condition. That's what I saw. And because when you read the 500, everything has to be intact, maintained. That doesn't tell you anything. So you have to have a description of what you saw. And then a listing of the specific provisions of the code or other applicable laws, ordinance, bylaws, or regulations that appear to be violated. If you have other regulations, if you have a bylaw that you also mentioned, you can double up on that. Some people will use the housing code and the nuisance statute for however they're working with the two things. So they're doubling up on that, and that's fine. But you have to have some sort of information in there for them. This is continuing determination if the violations are conditions deemed to endanger, and any other condition that's not listed in 630, the old 750, that you say is a condition deemed to endanger. You make that call. And so if they are, you have the right to do that. And if that's the case, that something comes up that's not covered in the code, but this instance is very dangerous, you can list it as such and order it in accordingly. And then your signature with this inspection report signed, certified under pains and penalties of perjury. This is really not much of an issue at the time. It's now been changed. It's now the occupant's legal rights and responsibilities. Used to be rights and remedies. I had no way of knowing if those were ever sent. Every once in a while I would see those, but for the most part, I'd say out of the 500 folders I saw, maybe 20 had it. So and I would be willing to bet in most cases they send it, but they don't keep a copy of it for themselves. So that's what I think it happened anyhow. So for the condition deemed to endanger, and I promise I'll leave this alone eventually, but it's the one big one that just gets everybody in trouble. The code states each inspection of a residence shall include at a minimum the condition alleged to be in violation in those standards listed in 638. We already covered that, but this is the exact citation in the question. Where does that come from? Amy and I and Phyllis and I worked on the code for many, many years. We didn't sit around trying to come up with something that we thought was really cute and fun. It all stems from the law. So 127A, which was the enabling statute in 1972, that gave DPH the authority to promulgate a sanitary code. In the middle, about, well, maybe 3/4 of the way down, it will say said code or a supplement thereto shall designate those conditions which when found to exist upon inspection of a residential premise shall be deemed to endanger or materially impair the health or safety of persons occupying the premises. That means DPH had to come up with a list of what those violations were, and Howard did many, many years ago. So that's where the whole thing comes from. It comes out of the law, and the judges, clerks look at both when you're in front of them sometimes. So
we had a few questions in the
yep,
chat. Do you like them now before you go over the form?
Yep, no, go ahead. Yeah.
Okay. Okay. One Daniel Hassett says he started citing the specific wording of the code as a reference and then placing the actual infraction in bold after it. Like, here's what the code says, and here's specifically how it applies to your situation. That sort of sounds like what you were saying about the hole in the wall.
Yeah, well, you can do that, but and some people, a lot of people put the actual citation in the order or the report. You don't have to do that. It's not required. You have to put the proper citation in there, but it only mentions you put the appropriate citation and your observation. So you can just list 500 and say hole in hallway wall. That something like that. That meets the standard of the code. A lot of people like to put each section in there because it's more descriptive for them. It seems they think it, I don't know if they think it has more authoritative value to it, but it definitely comes right out and says exactly what's expected, and then a little description of what you saw to make it a little bit more clear. So you can go well above and make it as descriptive as you want, but the bare minimum is the correct citation number and then an observation or description of the violation. The description is your observation.
Right. Okay. That sounds pretty similar. If you have a follow-up question, if you could put it in the Q&A, that would be great. The other next question is, can you use, I know we haven't gotten to re-inspections yet, but one question is, can you use a new inspection form for the re-inspection?
Yeah, you can. You're going to do a lot of copying over, and we're working. I came up with something. I know well, I'm going to spoil the ending. I'm working on something. DPH is working on something that's going to help you make this a little bit easier. So that's coming. We're getting real close to that. We're almost there. Is
Okay.
there another question yet?
Yes, there are a
Oh,
few
okay.
more.
Go ahead. Go ahead.
Does the specific inspector have to be an inspector from the municipality or an independent contractor? When you were talking about those special inspectors that are required?
Well, special inspectors are usually what the code's referring to is building, wiring, mechanical, plumbing, something along those lines they're usually within your community and another department. If you're
Right.
talking about an inspector outside of the community, I think, and I was never worked for a Board of Health except for Worcester, and so I don't know if someone else coming on. I think with all the PHEs going around, there have to be agreements set up if an inspector is going from one town to another. So I think that has to be in place. I don't know if I'm answering the
Yep.
question the
Nope,
right
I
way,
think you
but
are. Yeah.
it pertains to more of the professional license of different disciplines and not someone from out of town, if that helps.
Thank you. That does help. A few more questions.
Okay.
Um, well, actually, one of them is about the form, so we'll wait till we
Yep.
get there.
Gotta wait.
And another person has said, we list our conditions deemed to endanger in red font and the rest of the code in black. Is this acceptable for designating a condition deemed to endanger, or would we also need to note that somewhere? Conditions in red are considered a CDE somewhere on the report.
Yeah, you would want to say you would want to put somewhere in there any violations listed in red are conditions deemed to endanger which may allow an occupant to exercise their legal rights and remedies. I've seen, and there was a number of ways that people did it, and I think it's fine. There was 2 or 3 places that each violation was given an item number, 1, 2, 3, 4, 5, all the way down, and then underneath they would say items 1, 7, 9, 14 are conditions deemed to endanger. That's fine. Some people would do an asterisk in bold, and down at the bottom there'd be like a business letter, an asterisk, what it means. Some people had a table put in there, and there would be a condition deemed to endanger column with a check or a yes or no, and then an explanation that what that means. That's any way you do that to set it off, as long as you accompany that with a statement that's saying these are conditions deemed to endanger which may allow an occupant to exercise their legal rights. As long as that is included in there as well, you're fine. So however you want to highlight it, that's fine. But the ones I was talking about in the beginning, when I said they didn't identify them, what I meant was they would put the right number down, the right citation number, but they wouldn't highlight it, and there was no explanation that it was a condition deemed to endanger. So there was no way of telling the owner that some of these carried a different weight than the other ones. So that's what we're talking about.
Thank you. There are a few more, and if there are any of these are something you're going to come up to, just tell me to pause.
Okay.
One is when we have a violation and multiple code sections apply, should we list all the timeframes or just the most stringent and applicable one?
I think what you mean is list all the different citations, which will have different timeframes. Judge, when we first did the PIT class in 2009, we did Boston Inspectional Services, and Judge Winnick was there. And then I asked other judges as they came through, and because I always believe that the best thing to do is cite any violation that applies. So if you have multiple citations address one issue, you list them that way. And we posed that to the judges because a lot of people said, there's no point writing all that stuff because we have enough. And the judges said, I would rather see everything because it paints a better picture to me as to what the conditions are. And some of the ones that you might have left out carry more weight with me than the ones you use. I always like to liken it to when you watch the shows on TV and they'll cite somebody for murder of the first, second, and third degree, jaywalking, trespassing. They hit them with absolutely everything. So if something gets thrown out, they still have something else. But the judges have always said that they prefer to see as many applicable citations as that may apply to each type of violation. So the answer is yes, cite multiples. There's nothing wrong with that.
Thank you. I think the final one that you are not about to address is when you were talking about the third-party inspectors. The question is, we can order them to seek a third-party inspector, correct?
Well, this is something that I've spoken to Cheryl about in the past, and I've never gotten a true direct answer. I know she isn't in favor of that, and I think you had to find a violation first, and it all stemmed on the fact that you had to find something wrong and then possibly order them to follow up and go beyond that. And it stems from hiring someone just based on hearsay. So if I used to do this with mold many years ago when we were doing trainings. I would say, how many people deal with mold and site mold? And people would say, well, what we do is when an occupant calls up and say they have mold, I call up the owner and I said, get a licensed inspector in there and do a mold test. And I always frowned on that. And the more I talked to Cheryl, it does violate their rights in that. And this used to come in the same play with lead. So this is how I know this part, because we always had this issue. Is you can't order someone to incriminate themselves. So in other words, by saying, well, I haven't seen anything wrong, so hire someone and see if they can find it, doesn't fly. If you have just cause, which means you've done an inspection, you've found something, and maybe order them to hire more detail, I think that's okay. But just to come right out and say, I'm not even going to look at it, just go get someone, I don't think that works. Like a lot of times people say, oh, it's cross metering. I don't even get into it. It's too difficult. I tell them hire an electrician and get it done. I don't think that is legal. Now, on the other hand, this is a caveat I always talk about. If the court doesn't balk at it, you're okay. But if they do, don't be surprised. So not being a lawyer, I can't say one way or the other, but I've always leaned to the thing that you have to find something before you can order them to do anything.
And some of those things, of course, would be things you might not have the full ability to identify, like asbestos or lead. And in that
Correct.
situation, that would be fine to
Correct. Yeah,
okay.
I think yeah, those you're probably okay. But it's a little tricky with that. And just don't get in the habit of saying, take a phone call, yeah, and just go order here, you go do it. I don't want to do it. You can't do that. So I don't think it would, but just that's where we're heading. Anything else?
Nope, that's good.
All right. So this form is the one, I think it's on the website now. And honestly, I don't go to the website anymore. I don't know why, but I just don't go. This form was originally written by Kathleen McVarish at BU. It was used as a training tool in the FIT class. And that's why, can you see my mouse? Is my mouse working on this thing? Okay. It was originally set up as a training tool because we would have all of these different areas set up so that you wouldn't miss an area. So I'll go through the other pages. The types of violations that may exist and possible code sections. Now, and then you have to have, oops, I shouldn't, my mouse is one of those things, I'm not going to touch it anymore. But you can see responsible party off to the side. I tried using this one time when someone called to ask me to do an inspection with them, and I didn't like it for a couple of reasons. I didn't like having all of these types of violations there, and I didn't like all the possible code sections. And I noticed when some people use this form as is, they would write what the observation is, and sometimes they circled one of the possible code sections, and sometimes they didn't do anything. But right next to the one, like if it was locks, they'd keep it on that line, but they would just say lock broken. And I never really saw where it was quite, it didn't explain enough, and it limited me to what I wanted to do. And I'll show you what I came up with afterwards. And I'm not picking on anybody, because I think a training tool, it's really good. It doesn't work quite that well for me. And some people I've talked to others, and they said, yeah, I take all that stuff out and I write in as much as I want, and I don't bother having the rest of the stuff. So people are looking at it that way. And there's several pages. It covers everything. It's very comprehensive. And for training, I think it's good. If you're new, I think it helps because it gets you in the right direction. But if you're going to use this, you've got to make sure you're not just citing, like take living room, dining room in the middle here. The possible citation, 220, 235, 300. I mean, you're going to have to circle something and get even more specific. So I don't know if it helps that much for your order. It probably does to get you pointed in the right direction. And then the other one, when you look at the responsible party occupant, and it just has 240, there's more you can hit them for than just 240. So I'm not too crazy about that part either. And yet it goes on, and then I've got some stuff over my screen. Okay, reinspection form. This was new to me when I saw this, because I knew that there should be some sort of reinspection form based on what I'd seen with this capacity assessment. And I said, oh, well, this works okay. But then I started reading a little bit about it, and I think it gets a little cumbersome when it says written description of any violations checked above. So you go up top and you write everything, you write what it is and this and that, and then you describe it down here. And then this is where you enter your reinspection and the time frame. So to me, and I understand that you're really struggling for real estate when you're looking at forms. So I see where this is, and I get it. But I tried to come up with something. I talked to Amy about it, and Amy and Catherine are working on the same thing. But what I did is I was talking to them. What if we went landscape? Because I noticed even in landscape, if I've got a clipboard, I can write in landscape form. It's not that much different. So I didn't think it was that big of a deal. So I put a few things in here that I thought would help. The dwelling, the type of property that it is, just a checklist to have an idea what it is. But you notice I took all the other stuff out. You have to put the area in yourself. You have to put the citation in and the description. But then when you have who's the responsible party, we've got the condition deemed to endanger right there. The dates for correction are right there. And then the reinspection and the date. Was it corrected or not? So you have everything on one page as you're going through. And when I saw how people documented it, even the ones that did a really good job of documenting everything, it was kind of duplicate. They have another sheet for this and another sheet for that, which, God bless you that you did it. But I think something like this might work. So we did this, and then there's a couple more pages that are attached. But then at the end, this is the top part is the same thing that's on the other form where you have to have the signature. But then you'll see here is where I put in violations identified as CDE, conditions deemed to endanger, on and on and on and on. And then the next thing I put in there was the fact about in accordance with 610, if a portion can't be completed because you need a specialized inspector, then you can have to do that. So here I said, well, why not put a little space in for more information? I couldn't finish because I need the plumbing inspector. I hope to get him in here next week, next year, next month. I don't know, whenever it might be, your best guess. And then any additional observations that aren't necessarily description of a violation unless you want them to be. So I sent this form to DPH General Counsel. And I'm going to show you the order now too in a minute. And the two of them put together, the general counsel agreed that it meets the spirit of the code and would be okay. The only thing, and I want to be very clear here. The only thing that they preferred to see the area and the possible citations in there. And I understand he didn't say I had to do it. He just said, I would like to see that. And I think community sanitation is going to do that. I wanted to just leave it blank so it wasn't that confusing. It's not as helpful, but if you get to know the code or you have the code with you, you can still manage that. I wanted more room for the description. And then they also wanted me to spell out owner and occupant under responsible party. The problem is more real estate again, so I'm trying not to do that. And then CDE listed out conditions deemed to endanger, and I know they're working on that at the state to spell that out. So I'll leave all this up to you. If you want to use this, you can. If you don't want to use it, you don't have to. But I'm just trying to show you how I think you can consolidate, and it's been somewhat approved. I don't really want to say approved because I didn't ask them to approve it, and they're not really in the business of approving these types of things. They will just say it has to meet the code. If you have any questions, contact your town council. Yes.
Well, the people in the panel and in the workshop would really like a copy of this, so we can reassure them that we'll be sending an email out after this.
I did send it to you, right?
Yes.
Okay. Just understand, it's not an officially approved DPH version. It is, DPH has said it meets the spirit of the code. That doesn't mean the court will. I don't see why they wouldn't, honestly, but I just want you to understand it doesn't have a good housekeeping seal on it, because they don't do that, and they're not supposed to do that. They're supposed to say, this is okay, not okay, but you want to get into the technical part, use your attorney. So this is what I came up with.
There are a few
Then
more
we'll get on to the,
questions.
yep,
Oh,
go ahead.
So this is, if there are no violations, should that be noted on the re-inspection page? No violations noticed at the time of inspection?
If there are no violations, you send a statement to the occupant and the owner and a copy of the report with nothing on it, where it's just like no violation. So you have to send a letter to them. That's in the code as well. So you do follow up with a no violation letter.
Okay,
And there's no template that I know of for that. It's just on such and such a date, I inspected, no violations were found. You know, here's a
Right.
copy of my blank inspection report. So
thank you. Another question is, if you find a condition deemed to endanger, but you can't finish because you need the building inspector or someone, should you continue with the correction order right away to address the conditions deemed to endanger?
there's also a section in the code that if you run into a condition that is so dangerous that you have to deal with it right away, you could suspend the rest of the inspection and deal with that. So if that's the case, yes. If you want to, you could issue an order if things need to be done, if you're that concerned with it, and then pick up with a follow-up order when building and plumbing or whoever it is. So if it's something that really needs to be done that bad, then yeah, do it and then finish it later. Just document it in the back. All you got to do is document what you're doing for your rationale, just to show everybody, well, there really was I had an idea when I did it, not just I decided to go do this.
Great. Another quick question is, you had a bunch of different kinds of housing. At the
Yes.
top for check marks, is a sober home, a rooming house, or a shelter, or something different?
Sober home is a well, a sober home is a rooming house. Because the very specifically the sober homes, because when they were first set up, I don't know if this has changed, but I was working with I forgot the drugs, one of the divisions. I forgot, I can't think of the name right now. When they were setting this up, and it was that the occupants were paying a rent, even if it was a small amount, they were paying rent. So that made it a rooming house, and they understood. If that's changed, then you have to get an interpretation on a DPH. I don't think it has, but that would be the basis. If it's a charitable organization where they just let people stay there, then it's like a multi-family, not a could be multi-family, but a multi-room home if there's no rent being paid. So it's either a rooming house or a dwelling.
Thank you. And I know we're about to move on to order to correct. So people with the order to correct questions will be met then. You have one last form question, which was, can I take basic notes during the inspection, transcribe it onto the proper form, and then send that version along with the order to correct?
Yes.
My handwriting.
Yes, it just, yep. It doesn't say you have to do it on site, but you have to fill it out and it has to accompany your order letter. But you can do it. That a lot of people do that.
Thank you.
Nothing wrong with it, because you want to go back and double check and make everything's all right. So now we're doing the order. If you look at it, the order to correct, every order authorized shall contain statement of violations, cite all that apply. You're going to get a common theme here. Conditions deemed to endanger, copy of the inspection report, notice of a right to a hearing, and the procedure when you request a hearing. You have to do it in writing. You'll get all copies and everything. All occupants get to do the same thing. You have the right to be represented. You have to have a time frame for compliance. The fact a statement that a reinspection is required, have to have it translated in all language if the population of the community is greater than 1%. And then a statement advising the owner that conditions deemed to endanger may allow the occupant to exercise their statutory rights. We've been saying this over and over, so I just want to kind of move on a little bit with this. Proof of service, these are first class, maybe. When Judge Martin in Central Mass said you could use first class, some judges, I've been told as we're doing this class, they send it both certified and first class. If they don't sign the certified, you don't get the first class back at service. That is clerk and judge specific. So you just check with them first, because nobody else can make that determination but them. They get the final say. Constable, probably one of the best ways, because you can get service done quickly. Posting is much more different, very expensive, and becoming very complicated, because you have to post the property and then you have to advertise in the newspaper of record of the town where the home is, the unit you inspected is, for 3 out of 5 consecutive days. A lot of people are online now, so those questions are starting to fly up. What do you do about things online? There are advertisements online, but people getting their news in different ways. It's probably not as efficient as it used to be. I don't know if anybody's challenged it anymore, but it's just something to keep in the back of your mind. But it's expensive, so that's probably not one you're going to want to use. FedEx, UPS, or other means requiring an electronic signature. Yeah, UPS or FedEx comes, everybody answers the door because you're going to get something good. As opposed to certified, you know you're going to get something bad. So those are acceptable. That is also court specific. That is in the code now, that is in the regulation, so hopefully that helps carry weight. And copies to affected persons. So the code specifically says an affected person is the occupant if the owner is responsible for correcting the repairs, and the owner if the occupant's responsible. And when you send anything to the affected persons, you can do it however you want. There's no requirement for proof of service when you're sending copies to the affected person. You can hand it to them, you can email it to them. If you email it to them, email it to yourself as well. So if they say, I never got it, you can say, funny, I did get it. So you can do it any way you like that. Text to them. Everybody's going electronic, especially people now, no, text it to me. That's fine. Just keep a record of it, keep track, and let people know what you did, because there's no requirement for proof of service when you're just sending out a copy. Timeframes within 12 hours, or to keep good faith effort is a key here, to correct within 24 hours of those that are 630, and within 7 days, anything else up to 30 days. 30 days for your original order is the max. I don't know where the 30 days came, but it's always been in there. We could never change it. So 30 days it is the maximum. So anything that's not a correction condition deemed to endanger, it's your choice how many days you want to give them. The only thing I would say is be consistent with the amount of days you give for similar violations in other places. So the more consistent you are, the more credibility you have. And know what, the order can't exceed 30 days. Good faith effort. What does that mean? People are saying, conditions deemed to endanger, even though they're on the list, they're not necessarily a problem, because if you look at 500, when it says it subjects, like a hole in the roof or something, subjects them to shocks, burns, trips, or falls, and a doorknob smashes into a wall and breaks the wall, that's not a condition deemed to endanger. And DPH has agreed to that. We're identifying, along with Catherine and Amy are helping me on this, we're identifying those areas where, even though they're conditions deemed to endanger, there are conditions where they wouldn't be a condition deemed to endanger. So stay tuned. We're trying to work on some sort of, I don't know if it's going to be an advisory, it'll just be in training, but we're taking that into consideration, because I agree that is true. The good faith effort would be, you get a contract. I can't get there. I just ordered the windows. I got the plumber coming in 2 days. Here's his contract. The plumber calls you, says, I can't get there today. I can get there tomorrow. If you're satisfied with the effort, it's a good faith effort. So they have met that 1 day requirement, and then you can work with them for a future schedule to get the repair done. But just be consistent with that. So if you have a condition that you really don't like, it's really not one to endanger, it's not that bad, but you can't figure out a way to do it, just say, this is what you do something for me, give me something, so that I can say you met the good faith effort, and then I can go with some more time on that. You schedule your reinspection. You would do, if you're working with a good faith effort, you try and do the inspection just to make sure if something else wasn't, if they got something else done, you can give them credit for that. And then in your file, because you're going to need that if you have to go to court, what was the good faith effort? Write it down. What progress has been made? What is the new compliance and inspection date? So I'm going to give you a few more days. What is that? And tell the occupant. I used to get complaints all the time from occupants saying they're not doing anything. And I'd call up the Board of Health. They say, oh yeah, we were there. We did that. We talked to them. We gave them a few more days. Well, did you tell the occupant? No. Why don't you do that? I don't want to get all these calls. It was always about me at that point. So here's the inspection or the order to correct that we have right now. And I know we're getting there, and we're gonna finish. So this is the one it is now. But if you look at it, you can see right off the bat, you're taking some of the same information from the inspection report, you're putting it into a table here, and then down at the bottom, you have all the information you're supposed to have. And then the last part is, I don't know what, somebody asked me if I could tell them what all these languages are, and the answer is no. So don't ask me to do that. I have no idea what they are. But the the order, if it had, because it has to be 1%, these are the languages identified by DPH mainly through the lead program, because they used to have to do this all the time and keep up with the languages. So my advice would be just make your second page this, so that no matter what language you run into, you're probably covered. So this is what you have now. This is what I came up with. And when I went to DPH, I said, you know, it talks about what has to be on the inspection form, but it doesn't say an order form. So it kind of makes it sound like the order is everything, a statement for correction, all the information that's in here, the inspection report, this and that, and they agree. And I was really happy about that. So what this one does, and I can just tell you what's in here, and I think the way it makes it easier is you're not repeating steps between the inspection report and the order to correct. So what this has, it has just that opening paragraph, I was at such and such property, and then it comes right out. Violations are noted to the attached inspection report. Think of what's on the inspection report now as we go through. You are hereby ordered to correct these violations within the noted timeframes listed on the inspection report pursuant to 640. Failure to comply may result in court action. So that's telling them that they're ordered to do it. You have the right to request, and it tells you the timeframes. Remember, the timeframes are on the inspection report now. Put it all in one area in one page. So the getting everything organized in one spot. You have the right to request a hearing. If you request, you have to do it in writing. So you have to tell them how they have to do it. You have the right to inspect documents and all the reports and orders and any other documentary information. All affected parties shall be informed of the date and time of the hearing as well, and they have the right to be heard as well. So that gives them everything. And then at the end here, you have the right to be represented by the hearing. We're going right down through when you're going right down the list of the requirements in the code for what has to be in an order. And then you'll see, again, just to make sure, conditions may exist which will allow the occupant of the residence to exercise legal rights outlined in the notice of occupants, legal rights and responsibilities issued by the department. So that covers it. That's kind of going a little more emphasis. But then finally, with a reinspection to determine compliance with this order shall be conducted within 24 hours after the date of compliance of violations identified as CDE and 7 calendar days after the date of compliance for all other violations. Are you going to be able to hit that? No, because you don't know where they're going to get it. Even if you know when they got it, you don't have time to get there on that time frame. But this is just saying what this reiterates what the code is. So that's telling them what it is. Now, somebody said, I saw orders that said we will be there 3 days after the date that you received it. That's good if you wanted to add that. That's a little bit extra. You don't have to, but it's not, there's nothing wrong with being more descriptive. So if you wanted to throw that in there, that's fine. And then it gives the, yeah. You're muted.
Stop. It's killing me. You can finish to the end of this slide, and then you have a bunch of questions to answer.
Okay. Then it just talks about reasonable notice and access for the occupants. And then we put the compliance in there as well. A lot of people would put compliance in there because it spells out you have to use proper materials. You have to either you may have to pull a permit. If you do, you have to pull the permit. You may need to use licensed people. We're going to measure your complying with the code against all those things. You have to return it to the state that it was in its original state. It's like when I used to when I used to do that all the time, people went crazy with indoor, outdoor carpet and Luan. They had Luan on stairs and indoor carpet on posts, and you couldn't comply. So this is your standard that you're sending to them and saying, this is what I'm measuring it against. And if you don't meet these standards, I don't have to comply it and I won't. They're still going to argue with you, but at least you know you're on firm ground. I don't think you can ever get rid of the argument. And then the last page is the same thing again. So all I'm saying with here is, and then this is just the new legal rights and responsibilities, just that will go with it, and I just threw that in there so you could have it. I don't know if we're going to have time for this. All I was doing here quickly, and Regina will recognize this. This was Regina's favorite slide when she talked about writing orders. In a single family rental where you have owners and occupants, what would you write? And the first thing is there's strong order in the basement. Is this really accurate? Not really. And then I put this in here just to show what it may be a little bit better. Now, you wouldn't say here to the occupant and the owner, we're just trying to well, you could write over in this area and still hit who's responsible. But just say basements not being maintained in a clean and sanitary manner, noted an accumulation of rodent bait traps, rubbish, debris, including full trash bags, old flower pots, power equipment, also noted strong orders. And then for the owner, there is an evidence of moisture, standing water, area must be free from excess moisture, has a correction date. So it's just a way to give you an idea of what we're talking about. And then down in the comments I put, in accordance with, this is for the owner, with 500B, in the event of leaks and flooding, the owner shall ensure all surfaces have been dry within 48 hours from the time they are notified or the end of the event, whichever is sooner. Gives them a little heads up to say you're on a time clock for getting everything done like that. Service, we've already talked about that. I know we're running out of time, so I'd rather do the questions. Re-inspections, this is 24 hours after for 1 day orders, within 7 days after all others. It's a good idea to send your findings to the owner as well. It says the occupant in the code. Send it to the owner so they know. It can be your punch list for them. There's a definition of completed standards. Now we'll go on to anything else. I wanted to at least get to that part. So if people want to hang around, I don't know how you want to do it. I know we're out of time, but
none of us expected to be able to get through everyone's questions in an answer. So
happy to stay if somebody wants to ask. I don't know what you want to do, Phoebe. I'm going to leave all that up to you.
Yes, why don't you go back one slide just so if people want to look at it, they can. I will read you the rest of the questions, and I just want to reassure everyone that PDFs of the documents that Paul sent and these slides are already on our website, and the video will be there as well. And we can put them in Word as well.
Mm-hmm.
Right, the forms. Okay, here are some questions. You mentioned that DPH took a look at the draft housing inspection form you showed and said it met the spirit of the law. Does that mean that people could make their own housing inspection form as long as it also hit all those targets?
Yeah, well, you always could. There was never been, the code never said an approved inspection form by the department. What it says is the inspection form must include this, and it gave a list. So anybody can create their own, but it just has to have everything in it that the code requires. And it tells you in both sections, this must be on the inspection report, this must be in the order correct. But if you do it somewhat the way I did it, and DPH is working on it, you don't have to duplicate the effort, and you can kind of merge everything onto the inspection report and just use the verbal, all the verbal stuff in the order.
Great. Another question is, and before, in case anyone needs to leave right at 4, and you didn't at the beginning put your name in the Q&A, just so we can make sure you get your CEUs, please do that. Should a no violation letter be sent even if the town has a Chapter 2 inspection program? So a COC is issued when the inspection is completed and the rental property is compliant with 410. Does the COC replace the letter?
I don't know. I would say if your town council's happy with it, it's probably okay. The code doesn't take into effect that people do that sort of inspection, so I don't think that's ever been taken into consideration. I would say probably if certification of the unit means it meets the code, then that probably does the same thing for you. But I would just double check with them first, but I don't see why you would have to do both.
Thank you. Then we had a follow-up to the question that someone asked about writing notes and sending it later on. And that was, how do you get the signature of the occupant if you're not filling it out on site?
I don't recommend that you get the signature from an occupant. It's not required by the code. Not like food where you got to get a signature of the pick. I know a lot of communities over the years, they wanted it on there because they said, I want their signature to show I was there. And I've always said, well, if you do a thorough inspection, you got plenty of pictures, everybody knows you were there. The code doesn't require it. But the way I look at it is if you get their signature on something and then you have to change it, and say you can't use that page or use that document any longer, and you got to use a new document, you can't forge their name on there. And if you send them something back where they know they signed it, now there's no signature on it, you're going to start raising suspicions. It's there because I know people like to use it. I've never thought it was a good idea. But leave that up to you because it's not a requirement, so you do with it what you want. But I'm just not a big fan of getting it, just in case I have to revise something.
Thank you. Okay, we have, by the way, about 40 questions. So um, if they haven't corrected in 30 days, like they need a new well or a new septic system, do you have to do a new inspection in order?
No,
No.
no, you can you can do a hearing, you have to do some sort of review, and then you could come up with a new plan, but you don't have to cut a new order, because then there's no point doing another order, you already have it. But you can extend it through a hearing, just so that there's a legal process to let you do that. You don't have to rewrite it, no.
Okay,
And then
thank
one other point, some people, when they did a reinspection, anything that was outstanding, they reordered them to do what was outstanding. Don't do that, because now you're starting a whole new set of timeframes and a new clock. So just send them what the report says. You didn't finish this. Don't send them a new order, because you're only screwing yourself on that.
Okay, you can, by the way, move on to the next slide if you want, just so people have your email address. Do the 30 days include Sundays and holidays?
Calendar days.
Calendar days.
Says calendar days in the code. We finally got specific about that.
Excellent. If the inspection is done electronically, for the reinspection, should we start a new inspection report and reference the original, or print out the inspection report and write on the report for the reinspection?
Most electronic inspections that I'm aware of have a reinspection method where it either pulls those violations forwarded to a new document on a tablet, or you can just put something next to it. So I'm not familiar with one that doesn't have something like that. If you were using a form like this and you put it in form word, say on an iPad, you can still use the same page. So I'm not sure I know. If you want to send something to me, I'll take a look at it, but I'm just not familiar with something that would make you have to do that.
Thank you.
And I don't know all the software out there, so I just don't know.
Next question is there a requirement to officially serve a reinspection report if everything has been fixed and the person is an owner occupant?
Could you read that again?
If the person is an owner, it's an owner occupied place,
Yep.
and everything has been fixed, do they still need to send a reinspection report saying no violations observed?
We just send them a copy of the reinspection report with everything done.
Okay, that's what I thought. Can you identify mold, or do you need to say mold-like substance on the?
You've always been able to say mold. The reason you can say mold is there are no standards. So if you make a mistake and you say clean all that mold around the tub, and some smart ass says, well, I cleaned it, but I had it tested and it wasn't mold, you said, so what, I got it cleaned. What difference does it make? You don't need, there's no certifications in Massachusetts. There are no accepted standards in Massachusetts. There are no clearance standards in Massachusetts. So it's your professional opinion. We've all seen mold. We all know what's mold. And if someone were to say, if you went to court and the lawyer said, show me your certification, you say there's none required in the state. I don't have to have one. In my professional opinion, it's mold. It's mold.
Okay. Can the order to correct sample that you showed us be used as an order to vacate as well?
No, you'd have to change the language on it.
Yeah. Okay.
And I mean, you can work on the other orders. This was just going to a standard stuff. I didn't get into the emergency or any of that stuff yet.
Right. To clarify, just because a code violation falls under a section of 410-630, conditions deemed to endanger does not necessarily mean it is one. For example, finding 5 mice droppings cited under 410-550B can be 5 to 7 day deadline.
Yep.
Yep. Okay.
I would agree. The only thing I would say to cover yourself, when you have to cite you have to use the citation. It says it's a condition deemed to endanger. And I've been fooling around with the language. I haven't come up with anything I like yet. But if I were you, what I would say is put something in like, this inspector has determined that or based on the violation does not meet the conditions deemed to endanger as outlined in blah blah blah, however you want. But I would put something like in that to show that you have acknowledged that it's listed as that way, but in your professional opinion, that specific one is not a condition. It doesn't rise to materially endanger the health and safety of the occupant, because the 5 drops don't do it. So I would say put that in there, as a comment, just so that I've acknowledged that, but in my opinion, it's not. That's all.
Thanks. Fortunately, it's many of the 40 questions are people telling me they're here, so they get their CEUs. So don't worry. We only have a few more.
Okay.
Doesn't matter the inspection include a lead determination inspection? I don't totally know what that means.
Well, if you're doing a lead inspection, that's a different, I mean, that's a different inspection report. And
Okay,
that generates a different order and different paperwork and support and all that. That's a whole different separate, that's a whole separate packet and series of deadlines and everything. So I've always kept those separate because the code just talks about you have to comply with the lead laws. So I would keep that separate because Clip has the required forms. So that's different than forms that include what everything the code says from housing. That's a whole different matter. Their forms are very specific on what you have to have. So I just keep that separate. You can include it, but separate set.
thank you. The updated housing code removed 504 non-observant absorbent surfaces and moved the flooring requirements to kitchen facilities. For bathroom walls and floors not meeting the old code, should that now be cited under 500?
I think that's the best you can do now. I went back to DPH and Steve at Community Sanitation because I was hit with this question about a month ago. And it's true. So I had to go back through and research what version of the red line it disappeared, and I found it. And so I sent them the sections of both, and I said, we got to get it back in there. And I meant today, this morning, before I had to go do something else this morning, I meant to text them and see if there's an update yet. I don't know what they're going to do. They're aware of it, and all I could do is offer my opinion. It has to be put back in, whether you do emergency promulgations or you do some interpretation. I don't know, but something's got to be done because inspectors need it. So I can't go any further than what I did. You know, me can always give communities, call Scott. Call Scott every day and see what he thinks about it. You can give them a call. You can call them or email them. It's got to be done. I just don't know how they're going to do it. It gets tricky because of the legal stuff about dealing with codes.
Right. There's one more mold question. And then someone else asked about the pistol and hammer, by the way. Since most people weren't on when we were discussing it. Since not all mold is bad for our health, can we order the landlord to do a test on mold?
No, because it doesn't matter. There are no accepted standards for concentrations, counts, species. It doesn't matter. Mold is an indication that there is excess moisture. So that's all it is. I mean, you have to take care of the excess moisture and clean up the mold. But you can say that it's mold, investigate the source of moisture, because it has to have that moisture to grow. So you know there's a problem just because it's there.
Thank you. Is the occupant rights and responsibilities document required for owner occupied residence?
No, I don't. I would say no because, yeah, well, I would say no because they're not going to exercise their own legal remedies against themselves. And that's what the document says. They could, if you do it properly, they can withhold rent. If you want to give it to the owner so they can consider withholding their own rent, that's fine, but I don't see where that's necessary.
All right, last two. There was a follow-up question about the posting, people who want to actually do post in the newspaper. This person had checked with Amy, who had said you'd have to post the entire correction order in the paper. Is that right?
Yeah. Well, no, in the newspaper, we were always told you have to post the whole thing, but then there's legal advertisements that said there's an order to at such and such a property. The Board of Health did an inspection, orders to correct were posted on site. You must contact and such. I don't, unless that's changed. Amy might have found out there's other things going on, but when I used to post it in lead, it didn't have to post the whole thing in there, just to notice that there was an order to correct posted on property. And you had so many days to get in touch with me, something like that. But, you know, we can double check. Cheryl, I could double check with Cheryl. I don't think you need to. I could be wrong, but I don't think you need to.
And folks who are online, if we get any different answers to any of these, you know, if Paul comes up with different answers, we'll mail them out to you afterwards with the link to the video and the forms. Your last question is, you hinted that DPH was working on something for housing and it's almost done. What is it?
Oh, they're working on it. They're working on those two forms I showed you,
Okay.
the order and the report form, the inspection report. Ours are going to be slightly different. I already know that because sometimes I get a little pig-headed and I don't want to make the changes that they said would be nice. I don't always want to be nice. I wanted to leave as much room as I could for you to write in it. And when I was showing you the report, all of those different citations in there made it difficult to identify which one, and it wasn't specific. It only took it to the entire section. And sometimes I've had inspectors tell me I don't like all the rooms listed on the side because sometimes I don't use some and others I need to go further. So
Mhm.
the first time I tried using the form, I took them out because it made it easier for me to write kitchen and go as many lines down as I wanted to, rather than say, well, shit, now it runs into bathroom and I'm not done here yet. So that was the reason I took that stuff out.
Gotcha. Okay. I think that is all. People are asking where the video will be posted. We will obviously email that to you, but I also put it in the answer.
Will you email me too? I'd like to see if I'm right.
Yes. Yeah, so and if anybody wants to follow up, you have Paul's email address there. Thank you for going 15 minutes or more over. Everyone, I really appreciate, Paul, you're taking the time to do this for everybody, and also for everybody answering the questions as they came along, because I know that can be frustrating to sit through a whole workshop trying to remember when the questions are coming. So
I
if anyone,
appreciate being asked, and I hope it helped.
we are lucky to still have you. Thank you so much.
Thank you very much.
And
Bye, everybody.
everyone else, goodbye. Have a great evening.
So long.